Hello and good evening. My name is Victoria Moorman. For my ethics case study presentation, I will be presenting on the termination of treatment for viable infants with genetic abnormalities. The leading case for this presentation is Bowen, the Secretary of Health and Human Services, versus the American Hospital Association. Background relevant to the case of baby Jane Doe is the major issue of beneficence on behalf of the child that is strongly tied to non-maleficent action in the issue of termination of treatment for a child that would most likely live a fulfilled life with surgical intervention. The infant is given by her physicians a maximum of 2 years to live with non-invasive methods and palliative care. Her physicians also gave her 20 or more years to live with surgical intervention as an infant. An ongoing issue during the 3 years that the case occurred were several reports of the parents of baby Jane Doe being incompetent and unable to care for the child. These filed complaints eventually led to the involvement of Otis Bowen, the Secretary of Health and Human Services. The significance of the termination of treatment postpartum. The discontinuation of a pregnancy due to genetic abnormalities is not an unfamiliar idea in either the US or around the world. However, the idea or practice of terminating the treatment of a child postpartum who would otherwise live interferes with and confuses many ethical principles. There are many significant concerns related to both decision-making and the least harmful action taken in the consideration of the long-term future of the infant. A major factor in this case includes the unfinished case of baby Doe of Bloomington, Indiana, and the Bowen versus the American Hospital Association case was originally meant to be tried under the newly implemented changes from the 1982 baby Doe Bloomington, Indiana case. These implementations from the 1982 case were not necessarily followed in the 1986 finalization of the baby Jane Doe case. In regards to both the case and similar instances, life-saving courses of action should be implemented for infants born with treatable birth defects, regardless of the sentiment provided by the neonate's surrogate decision maker or personal physician. The image displayed depicts a neonate with spina bifida, specifically with an external opening seen on the lower spine. Baby Jane Doe was born with microcephaly, spina bifida such as shown, and hydrocephalus, which was a result of cerebrospinal fluid buildup in the brain caused by the spina bifida. While microcephaly cannot be treated, both spina bifida and hydrocephalus can both be treated and have generally positive outcomes. Ethical principles in conflict. Providing life-saving care to treat and continue the life of a child with a successful surgical outlook is a basic right, which is made difficult and more complex due to the infant's complete lack of autonomy. Due to the fact that the patient is an infant, all decision-making is directly given to the child's parents. Several complaints, both internal and external to the hospital, were made that questioned the decision-making capability of the infant's parents. Secondary to a lack of autonomy, the question of non-maleficent action remains, with the ideology of least harm done to the infant in the long run. Laws, codes, and duties. Following the Bowen v. AHA case, several amendments are made to the Child Abuse and Protection and Treatment Act. The Baby Doe law, resulting from the 1982 case of Bloomington, Indiana's Baby Doe, was a landmark case for instances of discrimination of infants with genetic abnormalities. A vital step for prevention of discrimination and unethical treatment was introduced to AHA hospitals in the form of ethics committees. These committees are in place to review instances such as baby Jane Doe's, where there is question of decision-making in regards to ethical commitment of the surrogate decision maker. Also resulting from the 1986 finalization of the Bowen versus AHA case was the implementation of in-hospital hotlines to alert possible discrimination seen by healthcare workers. These hotlines were later removed due to problems with federal involvement and overuse. Legal outcomes. One major flaw with many legal battles is the time it takes to form a decision. By the finalization of the Supreme Court case, the child was now 3 years of age, a year older than she was predicted to live by her physicians without treatment. Due to the pressures of both the court and the general public, the child received a shunt to relieve intracranial pressure resulting from hydrocephalus. Although there was instigation by the court, the overall ruling of the case was that the parents of baby Jane Doe were not acting unconscientiously or in discrimination of the Disabilities Act. It was also ruled that no American Hospital Association rules or laws were overstepped. All in all, there is a major draw as to the ultimate deciding factors of the case. Without the original pressures of the court to treat the child surgically, the child would have most likely passed away, leading to the court to close the case, as occurred with Indiana's Baby Doe. Without closure of the Bowen versus the American Hospital Association case, further instances of possible discrimination may have been overlooked. Furthermore, the completion of the case led to future instances being reported to Child Protective Services instead of going to random attorneys. Some solutions for the future. First and foremost, the presence of ethical committees in hospitals reinforces ideologies practiced by physicians, while providing assistance when ethical dilemmas arise. Additionally, contacting Child Protective Services instead of attorneys or federal court services, such as was done in the Baby Jane Doe and Baby Doe cases, would be beneficial for both the infant and the parents. Child Protective Services is specifically in place for neglect or discrimination cases, especially involving parent-child relations. Lastly, it is vital that court cases involving immediate and life-saving decisions should be promptly decided upon. 3 years after the birth of the infant is 3 years too late in most cases. It is of utmost importance that the life-altering or life-ending decisions be made with the foremost consideration that involves not only the infant's surrogate, but also includes the healthcare team, counselors, religious guidance if applicable, and an informed ethics task team. In conclusion, saving a viable life of an infant through the means of medical intervention is a prima facie duty that is principal to all physicians. Congenital defects do not justify the cessation of treatment for a suffering child.